All right, so unless you've been living under a rock, you probably have heard that the New York Times is suing OpenAI, makers of ChatGPT. I finally decided to write a proper blog article on this topic, which I'm discussing in this talk. So if you'd like to follow along, head on over to markhoglaw.com. You can find the link in the description below. First, a quick bit of italicized disclaimers, as always. This is obviously an opinion piece and is not legal advice. You should obviously consult an attorney. There is no attorney-client privilege produced herein, etc., etc. Look, in general, I do not believe that at a technical level, LLMs infringe on copyright. They just don't. Unless, of course, courts suddenly decide that, the mere scraping of data, of copyrighted content, without regurgitating that content verbatim or nearly verbatim, or without adequate fair use transformation, is somehow also an infringement. Or, of course, whether the end user has intentionally used the LLM to produce copyrighted content. So look, first, that just wouldn't be a tenable solution at all, right? So it's the creation of output and whether that output is itself copying and outputting verbatim or nearly verbatim without sufficient transformation the existing works, and therefore is not fair use. It is that which should determine whether, in fact, there has been copyright infringement. So not merely the reading, the scraping, the storing of that information. Because don't forget, the actual output from an LLM is not actually touching the training data. The training data is sort of a once and done thing every, 6 months, every year, whatever the time frame may be. But once it's used, it's, for all intents and purposes, effectively discarded. It's the output itself which matters, and it is truly novel. It's not actually touching that training data. It learned from that training data in much the same way one might argue that a human learns from copyrighted content. But let's dive in and understand what exactly is meant by fair use, because that is admittedly the threshold question we need to resolve. So the fair use test has 4 prongs. So the first is, is it in fact transformative? So transformative use are things like criticism, commentary, parody, also nonprofit or educational or for personal use. Commercial uses are typically leaning towards copyright infringement, but they too can be fair use if they substantially transform the original work or use it in new and creative ways. So the second prong is the nature of the work. So factual things lean more towards being fair use. Highly creative things are less likely to be fair use. And this is a really important distinction, right? Because the degree of production afforded under copyright law varies with the nature of the work. And when you stop to think about it for a moment, this actually does make sense, right? Obviously, if you are reporting on the news, this is factual, objectively true stuff. Well, theoretically anyway, I guess, especially depending on the news program. So obviously, the use of that factually true stuff should be allowed to be reproduced. That's kind of the essence, the nature of the news, right? But if something is wholly imaginative, created, fabricated from the mind, fictional works, this obviously is a creative thing and should therefore in general be protected. The third prong is the amount and substantiality of the outputted content. So obviously the more of the original content is used, then the less likely it is to be fair use. Right, and this kind of makes intuitive sense. But this also depends on whether the use is transformative and the nature of the work used. So in a sense, this third prong is kind of, I guess you could say, almost recursive with respect to the first 2 prongs, right? Extensive use of a work in a transformative or non-commercial or educational setting could still favor fair use. And finally, and I think this is in some respects one of the most practically, or at least the most objectively easy thing to recognize, is the effect on the market value of the original work, right? So if the new content adversely impacts, let's just say lessens the market value of the original work, then rather intuitively, it's less likely to be deemed fair use, right? We don't want some new stuff harming the commercial value of someone's original hard work. This factor assesses whether the new use effectively usurps the demand of the original. And again, this makes a lot of sense. By the way, if any of this sounds at all familiar, that's because it kind of sounds a bit like defamation. In general, at least under American law, if you're stating your opinion, so something creative, a creative thought of yours, an opinion on a person or on a company, that is in general not going to land you in hot water liable for a defamation suit, be it written libel or spoken slander. It's only when you say a thing and you present it as being factually true with the knowledge that it's not true, and of course if it causes harm and damages and so forth, then do you open yourself up to defamation. But something which is your original subjective opinion is generally not going to be defamatory. And that's kind of what we have here, right? So a thing which is creative, probably sufficiently transformative, a thing which is effectively copying and therefore not very original, not very transformative, and certainly a thing which is adversely impacting the market value of the original, probably not going to be fair use. So the question of whether an LLM infringes on copyrighted content, therefore, cannot and frankly must not hinge simply on whether copyrighted content was scraped, but rather it must go through each prong of the fair use test that we just discussed. I mean, alternatively, or perhaps additionally, copyright law really is going to need to change. I mean, this, I think, goes without saying. It's going to have to reflect the new era of AI that we're living in. But there's a strong policy argument, too, for what I'm saying, right? So if the courts rule that the mere training of LLMs, without more, is itself an infringement on copyright, then generative AI will effectively be cut at the knees, and humanity risks losing arguably the greatest invention since, well, ever, or as I've said before, since the Gutenberg press, really. I mean, this is a profoundly important decision that the courts have to figure out. Also, let's face it would effectively preclude a future which isn't really anymore in the realm of science fiction, essentially a world populated with AI-powered robots or droids. Because if the training of generative AI is effectively deemed to be copyright infringement, then we basically are going to have these robots that are little more than walking, or I suppose rolling with respect to a certain R2 unit, talking copyright infringing automaton. And we really can't have that. We just don't want that sort of a future, right? We want a future where AI is helping society. I mean, it's offering so much to us already, and it will only continue to offer so much more. So this is profoundly important. I mean, we risk sabotaging this incredible advancement in society if we don't get things right. Now, I think an even more practicable solution is more of the typical sort of UGC, that's user-generated content type clauses that pretty much every terms of service or terms of use for any product, video game, production software, or otherwise, put in their terms all the time anyway, right? This is pretty standard stuff to have on any platform where the end user can create stuff. Basically, it just says if you use the platform to do anything illegal, like infringing copyright, and this, by the way, is exactly what Midjourney does. You can pull it up. I believe it's paragraph 10. If you use their platform to do anything illegal, then the burden of liability is actually going to fall on you, the end user, and not the platform. And I think this makes a lot of sense, right? So just to give an example, right? If you use ChatGPT to create, say, scripts because you're creating a new, Udemy course, but you're pulling the content for that script from, say, other people's books or YouTube videos or whatever, that would be a pretty blatantly illegal use of ChatGPT, right? And therefore, you, the end user, should absolutely be liable for that. You're literally using a platform to do an illegal thing. Again, Midjourney says precisely this in their terms of use. So this isn't really such an outlandish idea. As I explained in my article, if you want to look at a rather more bludgeoned example, I suppose, if you intentionally drive a car recklessly and then crash it, it's not the car manufacturer's fault. If you spray cleaning solution in somebody's face, again, it's not the cleaning solution manufacturer's fault. I recognize that these are laughably, shall we say, superficial examples, but I think the point that I'm making is well supported nonetheless. So what I'm really getting at is that the issue shouldn't be whether generative AI language models can produce output which is infringing on copyrighted content. Of course they can, and they have, and they will continue to be, well, forever really. The question should really be two-pronged. First, is the output indeed an infringement per the four-pronged fair use test discussed previously? And, or, number two, was the infringement caused with intent by the end user? Now, assuming the first question is true, is the output indeed infringing? Is it not sufficiently fair use? Then if the second point is true, was it done intentionally by the end user, then the end user absolutely should be liable. But if the end user did not act with intent, then in that particular case, arguably the company, the platform, the AI platform is probably liable. So if, say, the New York Times allegations that ChatGPT was producing regurgitated content en masse on its own without any intentional sort of hacking or clever prompt engineering with the intent to produce copyrighted information in a non-transformative form, then yes, OpenAI absolutely could and probably should be liable, right? But it seems to be the case that more likely than not, the New York Times tried to coerce OpenAI's platform, ChatGPT, to produce this stuff, to regurgitate elements virtually verbatim from its training data. That's That's not okay. And the fact that that can be done doesn't in any way imply liability on OpenAI. Furthermore, with respect to New York Times v. OpenAI, that OpenAI was willing to partner with, that is, to pay other platforms for access to their content, for instance, Axel Springer, this implicitly suggests that absent such partnerships or payment, right, that they would indeed be at risk of copyright infringement. So that sort of shoots themselves, and indeed all generative AI companies, in the foot, right? So in other words, there's this argument that says, hey, OpenAI, they're willing to pay to partner with other platforms to scrape their data, well, presumably legally, without running afoul of copyright infringement lawsuits, right? I mean, and actually, OpenAI keeps doing it, right? And actually, it's not just OpenAI, right? So Reddit, too, for instance, has just struck a deal with Google, and some undisclosed AI company has also agreed to license its content for $60 million per year. And this, therefore, seems to further sabotage the argument that copyrighted content is otherwise fair game, or that it rather should be fair game, right? So why would you pay for content if it's, in fact, supposedly free to use? This is a pretty solid argument, except that it isn't. Here's the thing, though. It's actually quite possible to reconcile this seeming contradiction. So the decision to enter into licensing agreements doesn't necessarily contradict the fair use or non-infringement arguments generally. These licensing deals can really be seen as just good business practice, right? They're strategic, they're mitigating any sort of legal risks, and frankly, they're fostering goodwill with content creators. So it's kind of a proactive move for business and public relations generally, not some sort of admission that scraping is legally untenable, right? So moreover, these partnerships might signal a commitment, actually, to ethical AI development, in turn ensuring higher quality data obtained through consensual means. This is sort of a dual strategy that balances legal, business, and ethical considerations, navigating the complexities of copyright law in this new age of AI. So I don't really see any sort of problem with it. Oh, and by the way, what I'm suggesting here can't really be that outrageous. I mean, Japan decided that AI-generated output doesn't, in general, infringe on copyright. And almost as a corollary to that decision, China, too, recently declared that AI-generated output can itself be protected by copyright, which, by the way, is another thing I've argued for quite some time as well, because as a reminder, here in the US, things like copyright and patent can only be granted to a human creator. It cannot be granted to a non-human creator. So AI cannot get such protection as copyright and patent protection. The AI researcher, by the way, Stephen Thaler, he too has been trying for years to get his autonomous AI recognized as a creator whose output can be copyrighted just like a human. So again, what I'm suggesting isn't that outlandish. And in fact, I think for many of the reasons we've discussed, it's actually necessary, at least if you want to allow open to ourselves this incredible future of generative AI. So look, I realize what I'm saying, the things that I'm suggesting and arguing are really opening the door to plenty of criticism and rebuttal against me. Well, personally, actually, I get this. I've been to enough events, I've lectured enough about this stuff that I know how it goes. It's an admittedly something significantly less than half in a room of attorneys that tends to disagree with me on this. But so be it. That's what's awesome. That's what's amazing. That's kind of the nature of this stuff and really why it's so exciting for me, both personally and professionally. Now, I get it. For all you content creators out there, very likely listening to this, you're probably pretty enraged. And if you are, you should, rather than just sort of throw that rage blindly at a wall, or indeed at my face, I suppose, this should be discussed. This needs to be a two-way dialogue, and there needs to be a resolution. You know, maybe there are ways for you to get a certain layer of protection for AI training. I don't know. But at the end of the day, there needs to be some common ground found as between generative AI companies and content creators, because if we don't get this right, we are severely ruining and sabotaging an amazing future for all of us. Thanks for watching.